All right, so I'm testing out our YouTube live stream today. It seemed like a good day to try it out. All right, so live stream's up. We are officially getting started. It is 9:15. This is the probation and non-jury calendars. What we're going to do is I'm going to go over a quick PowerPoint just to get everybody on the same page, and then we're going to call the calendar. So I want to start out by saying that here in the Spalding County State Court, this is the Spalding County State Court. My name is Josh Thacker. I am your judge, and this is the probation and non-jury calendar. I want to start out by saying that here in the Spalding County State Court, we believe that each of you, as you interact with this court, deserve the respect and the dignity that you would wish for someone you care about. We will extend that to each and every one of you as we interact with you all here today. Hey, don't talk during court. Our goal is to return you to your lives as soon as possible. You'll realize pretty quick I will not have much patience with disruptions. And again, our goal is to return you back to your lives. Nobody is virtual. Cell phones. Everybody grab your phone out of whatever pocket, purse, or pouch you've stashed it in. Absolutely, positively make sure it is off. If it rings after this moment, then we have to have a conversation neither of us want to have, and it's a very preventable thing. Don't volunteer for that. All right, this is the correct courtroom for you. If you're on probation with the Spalding County State Court, you're being supervised by the Sentence Enforcement Office, or you have some other motion that you need me to hear. Actually, I can take that off now. I think we're officially finished with our bench warrant walk-ins. Okay, I'll remove that. All right, this is not the correct courtroom for you if you received a citation from the City of Griffin Police Department and you're supposed to be in the municipal court. I know the bailiffs already sorted this out, but is there anybody here who recently received a citation from the City of Griffin Police Department and you're here on your first court date? All right, great job, bailiffs, as always. Okay, you're supposed to be in Superior Court. I don't think there's Superior Court going today. No, okay. All right, Janet Harmon Bragg. So I need help, and I'm asking you all to help me. So here's what this looks like. Janet Harmon Bragg was the first African-American female commercial pilot in the United States, and she's from Griffin. This is the beautiful mural that has been painted in her honor and memory. When you all signed up to report to probation, you agreed you would park there. And I know everyone here always parks there, but other members of my tribe do not park there, and they park in all kinds of places they are absolutely, positively not supposed to be parking in. And so every Wednesday and Thursday, my phone lights up with angry business owners saying that somebody's parked in front of their driveway or on the sidewalk or just in a place that no reasonable human being would even think is a place to put a car. So I need your help. So here's what we're going to do. Today, when we're finished, you're going to get a next report date, very likely. The next time you report, of course, you'll park, as you always do, at the Janet Harmon Bragg parking lot, which is catty-cornered to the office. When you walk in and you sit down in the lobby, you're going to turn to the person on your left, and you're going to go, hey, where'd you park? And they're going to go, I parked at the post office. And you're going to go, you need to go move your car to the Janet Harmon Bragg parking lot. And they'll say, thank you. I really appreciate not going to jail today. See how that works? That fits. Okay, nods. And then you're going to do the same thing with the person on your right. And this is getting better. I'm getting fewer and fewer notices because I'm deputizing all of you all, or knighting, or whatever term you prefer, saying help your tribe members not go to jail. So y'all please do that every time you report from here on out. All right, so calendar call procedure. So we're about to call the calendar. When you hear your name called, stand up. If you have an attorney, let your attorney announce for you. And actually, we don't really need the announcements because I'm just going to call the probation calendar. So you just need to say here, that's all I need from y'all. So I just realized with our new system, I need to retool this PowerPoint, but that's a really good problem to have. All right, so we'll just do it this way. All right, so first case on the calendar is Jeremy Kaler in jail, I believe. Is he yours?
He's in the back. I believe we can work that out today. I think he's a good candidate for veterans court. That said, he has just gotten out of medical. He had a mini stroke the other day while in custody. So he could be everybody's best interest.
All right, well, we'll let y'all conference here in just a minute, and then y'all can tell me what you need. All right, perfect. Larry McCoon?
Here, sir.
All right, thank you, Mr. McCoon. All right, again, I am the luckiest judge in the state of Georgia. I have great teams in every direction, the best in Georgia, in my opinion, and y'all have worked out this huge hairball that was all the different cases with Mr. Pittman. So I just wanted to say thank you to the Jukes firm and to the solicitor's office and to Director Matthews and her team for communicating and getting all this sorted out. So, yeah, great job, y'all. Yeah, that's it. That's all you got, right?
That's it for us.
Y'all have a great morning. Again, thank you. That was a beast, and y'all did a great job.
We'll see y'all Monday. Yeah,
All right, so that takes care of the rest of page 1, all of page 2, and then that just leaves us with page 3. Which brings me to Patricia Poole.
That case is awful.
Wonderful. All right, Amber Redding. Not here. Redding? No.
That's for a probation warrant holding.
Redding.
I think that probably didn't pay it off, right?
Just after one day.
Wow. That's all right.
It's such a dumb way to go to jail.
I know, like, so preventable. But if you're gonna work that hard, I will honor that effort. So, golly. All right, Spears. Lisa Spears. Any response? No?
Probation warrant total.
All right. Yeah, the people to case ratio is getting off here. All right, assign that one for Spears. And then Newman, she's here, okay. For a limited permit. I have that,
Newman asking for a limited permit?
it just says pro se motion for limited permit. Is that right, Ms. Newman?
Yes, sir, you issued me one, but I took it right after my doctor's, right after I got in the mail, the medical evaluation. And they held on to it, she didn't tell me I had to be there personally for her to fill it out, and they called me when it was too late.
Ah,
They had
okay.
30 days.
Hold that thought.
I got it faxed to DMV.
That's all right, hold that thought, we'll
Yeah,
put.
I'm opposed to that. She does not need to drop it.
So, well, I have a vague memory of sending in that the notice to revoke and require retest. That's the last vague memory I have of Miss Newman. Well, so we'll come back to you, ma'am, and talk this through. Okay, so, so that just leaves, Mr. McCune here. If, let's talk through the folks who are else here. If you were here and your name was not called, stand up for me. Got a couple, I guess. Anybody? No?
I think there's written this.
Oh, okay.
About the lady in the green shirt, but I think the lady in the blue shirt's for Kayla.
Okay.
Y'all agree,
Taylor.
Taylor?
That's fine. We just want to make certain that everybody's addressed and has traction here. All right. Well, then, what I'm going to do is we have Mr. Dutton needs to speak with Director Matthews and Mr. Shepard about Kaler, and then Mr. McCune. Do you have a offer for him? Mr. McCune, I don't think there's anyone else here. Mr. McCune, what's going to happen next? Just sit tight. Director Matthews or one of her team members are going to talk to you in a minute, and they're going to offer you a consent order to see if you want to resolve your case without a hearing. There's no pressure behind that question, so it's just a yes or no. So if they present you with the details and you're happy with it, you can sign it, and you'll be free to go after that. If you don't like it, no problem at all. You just say no thanks. But I just want to make certain I've communicated clearly, like I do every Thursday, that it's not a negotiation. It's just an up or down. Yes, you'll accept that offer, or no, you want to hear it. Okay. So, so they'll talk to you in just a minute. No pressure, but that's what's about to happen. All right. Thank you. Okay. Then I'm going to. Anybody else need me to make an announcement? Okay. Then I'm going to put us in recess until y'all come get us. All right. We're in recess.
Yeah, just come through. You're good.
Record, so just a quick couple of odds and ends. Looks like Mr. McCoon decided to sign his consent order. Okay. All right, I've signed it. There you go. Ms. Newman, come on up. Let's talk for just a second. Just come to the podium there. Raise your right hand. You solemnly swear or affirm the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
All right.
Yes, Your Honor.
All right, Ms. Newman, you're here today. Let's do it this way. You're here today on 24 SR 0288. In 20 seconds or less, if I did exactly what you wanted me to do today, what would I do? If I did what you wanted me to do today, what would you have me do?
Hopefully make my permit because I'm able to get my license back July 11th. And I have my substance abuse evaluation scheduled for 1 o'clock today here in Griffin. And I've completed DUI school, and I took it to Dr. Harvey like 5 days after I got it from DMV. But they called me on the 7th, which would have been too late, to tell me that I had to be in person for her to do it. So I panicked Friday and went and retrieved the letter from McIntosh Trails and took it to my primary care, Joshua Pugh, and he faxed it to DMV, and they said they had it, but that I had to bring it before you because my other doctor held on to it too late. And I tried to go talk to her last Thursday, and she was on vacation, and she's only in on Thursdays. So,
Okay. I don't see anything in here that has something for me to do. Because I'm looking at your paperwork here, and it's helpful. I don't want to say wrong. I mean, you've got stuff from the Department of Driver Services telling you, you've got this going on and that going on. And remember, I said I was going to send in the thing that said, hey, she needs to be checked from start to finish.
yes, sir.
Because my memory of the plea was that you were not going to be driving anymore at all. And I just said, I'm going to send that in. Did I misremember you telling me that you had no intentions of driving?
Well, with my limited permit, took it to my doctor's appointments and my probation and everything. I need to be able to drive.
Sure, but my memory is somebody correct me if I'm mistaken. My memory was you said you had no intentions of driving anymore at all. That
No,
was my
sir,
memory.
that's what solicitors, if, I did the accountability court for 2 weeks, but due to them not being able to go against my doctor's request, it disqualified me for the program, but it wasn't to my fault. It was, but, I think that was if you, Mr. Shepherd, you had stated if I didn't know right from wrong, then I shouldn't be able to drive at all. But then I went ahead and pled guilty to the DUI and things.
Okay.
And Judge, just so you know, she's already had a positive drug screen and had to go to jail.
Yeah, I was just about to say that.
Yes, sir.
She does
Yes,
not,
I did.
Okay.
And I've completed everything, and it was a very well intervention that was needed. And honestly, it was a wake-up call.
All right. Here's what we're going to do.
Yes, sir.
Carly, will you give her a reset for a couple weeks out? I am not saying I'm going to grant this, but I need more information.
Yes, sir.
So before I'm even willing to consider it, so I'm putting a little sticky note on the front that you need to go back to DDS. I need to get a suspension detail report. So I don't have one here, and I need to know the information that's on that report. So as far as today goes, instead of denying it and making you refile, which is what I should be doing, I'm actually just going to let you get a reset notice from Ms. Evans. You're going to come back on another date, and we'll go from there.
Okay,
Okay.
yes, sir.
You need to bring, you see the sticky note there?
Yes, sir.
You need to bring that report back.
Okay.
In fact, I'm going to have you turn one in to, doesn't she check in with y'all?
Yes, sir.
All right, I'm going to have you turn in a copy with them and then bring it back to me. That way there's a couple of copies floating around.
Okay, and Your Honor, the DDS is ones, because I called it to my primary care to fill it out, and he faxed it to them. They said they did have it, but that it was too late, and they're the ones that told me I needed to come back to you.
Yeah, I
And-
heard you say
okay.
that, and I'm telling you that you're here and I don't have enough information.
Yes, sir.
And that report will give me the information I need.
Okay, and my substance abuse evaluation is today at 1:00. So
Okay.
I've gotten that to take care of too. I'm trying to do everything I'm supposed to do.
Okay, well, let's get you to do what you're supposed to do. If you will step out in the hallway with Miss Margaret, she's gonna have you sign your paperwork, and I'll see you whenever that date is on that piece of paper.
Okay, thank you, Your Honor.
Thank you.
Thank you.
All right, that was Alice Newman.
He put June 26th.
June 26th. Okay, so I'm gonna put no suspension detail report. Reset to June 26th. Ordered to provide copy to sentence enforcement. And as I said to her, I'm saying it again, I did not guarantee her that I would grant it. I just would like to make a decision off of the correct information. Okay, any other cases that need to be addressed before we step into Mr. Dutton's hearing?
No, sir, not that I'm aware of.
Okay, because I think that's it for me. All right, Director Matthews, if you'll raise your right hand. Do you solemnly swear or affirm that in all matters today you'll provide the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, you can take your hand down. You're sworn for all testimony today. Yeah, I show this is the last hearing. So, all right, so, Mr. Kaler, you may keep your seat there, but I'm going to place you under oath. Are you ready?
Yes, sir.
Do you solemnly swear or affirm the testimony you're about to give in this matter will be the truth? Any testimony you may give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
All right, the bailiffs are moving that microphone up to you. Couple of questions, Mr. Kaler. You are here represented by your attorney, Mr. James Dutton, is that correct?
Yes, sir.
Have you had enough time to speak with him about your case?
Yes, sir.
Are you satisfied with the job he's done on your behalf?
Yes, sir.
You ready to go forward?
Yes, sir.
All right, Mr. Dutton, Mr. Dutton, that was one of the bailiffs. Mr. Dutton, as far as, you have a copy of the petition in front of you there?
Yes, sir.
All right, so, so he's here today because the sentence enforcement team has filed this petition alleging that he's out of compliance with his probation. You have, is it A, B, and C are the three allegations?
That's correct, Your Honor.
Do you all admit any of these, or do you deny these, or a mix of the two?
It's a mixture, Your Honor. We are denying A and B in part, and we are admitting C.
All right, so A is denied, B is denied.
Again, for the purpose of this hearing.
Yeah, oh, yeah, for the purpose of this hearing only. C is admitted for the purpose of this hearing.
And that's a felony, so that'll be,
Okay.
the schedule one was THC oil, which is,
Oh, I see it there.
for what it's worth.
THC felony. Okay. All right, so, Mr. Shepherd, Director Matthews, the floor is y'all's to get this thing started.
All right, Judge, we're here on the 21 SR 1620, just for a little context. This is the third case that Mr. Kaler pled to. The first one was 21 SR 1618. He ended up pleading to obstruction on that case. That was a 12-month sentence. There was also a charge of criminal trespass under the Family Violence Act that was dismissed as part of that plea. The second case that ran was 21 SR 1619. That was battery under the Family Violence Act. So that ran consecutive to 1618. That was also a 12-month case. And then now we're on 1620, which is a 24-month case. He pled to all three of these on September 19th of 2022. The third case, the one that we're on for today, he pled under the First Offender Act, so make sure the court's aware of that. We've got a string of family violence cases. The petition today is that he failed to appear at a revocation hearing on May 1st of 2025. He failed to submit to 3 different drug tests. In fact, I don't believe we've ever actually had a drug sample submitted by Mr. Kaler. One of them was in October of last year, one of them was in November of last year, and the most recent one was March of this year. Obviously, there's a new charge that we just discussed. For a little more context, Mr. Kaler has had numerous drug charges over the last few years. I think at least 3 different occasions where he's been charged with methamphetamine possession. In fact, this case, 1620, had a methamphetamine charge that was reduced by the district attorney's office when this was transferred to us. So he's got a pattern of serious drug use as well as a pattern of family violence. I just don't believe that Mr. Kaler is any longer a candidate for probation, so the state's going to be requesting that we revoke the balance of this case as well as revoking his first offender status.
Okay. All right, Mr. Dutton, if I do what you wanted me to do today, what would I do?
Your Honor, you would allow him to leave the jail and go immediately to Leslie's office and begin the process of getting into Veterans Mental Health Court. Your Honor, what we've got is, I believe what extra complicates this case, Your Honor, is that there's 2 Jeremy Dean Kalers. There's a senior and a junior, and I've represented them both, frankly. The paperwork and the way that this was pled by Mr. Taylor's office is unusual to say the least. It's 3 different cases. It wasn't reduced in a way that would make it one case. It was due so that he had to plead to all 3 cases, which makes it seem like he's some sort of repeat offender when it was really one set of circumstances here, Your Honor. That, however, included specifically that first charge, the jail time was to be suspended upon completion of residential treatment. Your Honor, he entered a 12-month in-house rehab, and he completed that early at 10.5 months. Now, again, should he have stayed the whole 12? I'm going to let the professionals there make that determination. They determined that he should have left at the 10.5 months. That essentially completed 2 of the cases, the 12-month cases. This case that he's still on was, box 15 was checked. It's non-reporting. It's always been non-reporting. It's never not been non-reporting. He got out of the in-house rehab and reported every single month online, and it said, okay, your date's this month, and he paid his fines and fees. Notice that the petition for revocation doesn't say anything about fines and fees. He's continued to pay every single month. He's continued to report as he was informed that he should. Never online did it say, hey, you've been flagged, call the office. Hey, someone's going to give you a call. Hey, look for something in your mail. He continued to do exactly what he said. Your Honor, there was a revocation hearing scheduled that he missed, but there was still alcohol and drug testing that he allegedly missed after that time. And so, before that time. What we're looking at here, Your Honor, is he's never received notice that he ever had a revocation hearing, that he ever needed to go and drug screen. He continued to report as he was told to, that the sentence told him to. So, Your Honor, he did not appear at that revocation hearing. He did not appear and test. He was never told that he should. He continued to do exactly what probation had told him to do, and he continued to communicate with probation exactly how this court told him to. It was on non-reporting, but he still reported electronically. And so again, he at no point has ever been told until he got arrested that he needed to report, that he needed to test, that he needed to do anything more than what he was doing. And again, you can see that plainly because he has no fines and fees outstanding. He's continued to pay, he's continued to do everything he should have. That said, Your Honor, in 2018 and before, he had a severe addiction to methamphetamines. Since 2018, he has not consumed any of those or done any part of that community. He's been clean of that drug. He has, however, switched over to marijuana, specifically the THC oil. All right? The THC oil is much more for calming of nerves and keeping him copacetic as opposed to Cheech and Chong level indulgence. However, it is still an illegal substance, and he does need help transferring from that addiction on to something that's more manageable, something that isn't illegal. The illegal items that he had on his person at that point were all the same, were all based around that. And we're coming today to ask specifically for that. Your Honor, he needs help. He's willing to get it. He's done so in the past, and he's passed in flying colors and has done everything that we've asked him to do as a system. That said, Your Honor, you can see that there's additional issues here with the paperwork. For example, it says that he's on for family violence, battery, victim over 65. Your Honor, his victim wasn't over 65. Your Honor, if you look at the actual charging instruments, it doesn't say victim over 65 even there. So again, there are some paperwork issues here. No one's necessarily to blame. Again, there's a junior and a senior, and they both have previously engaged in a lot of vicious habits. That said, Jeremy Kaler Jr. Is now off probation as well. He's very recently off probation. Again, Your Honor, I do not believe that he willfully did anything other than what he was specifically told to do, other than continue to indulge in the habit of the THC oil, which again was not done for pleasurable. It was done for more mental health aid. And the first thing we spoke about when I met him this time in jail was, okay, what are we going to do? And he said, I do need help with it. I should have come for help long before. But it was on the list of sins, Your Honor. THC oil is, while illegal, pretty low down on the list. So that said, this is still something that is in the purview of the Veterans Mental Health Court, and it is something that we're asking for today, the opportunity to address that. Again, we don't believe he received any sort of notice. Mr. Shepard and I spoke, and he said that Director Matthews called, or someone from their office called. When I spoke with him, he said, I've never received any calls. I checked online every month. It said, see you next month. He's paid his fines and fees. He's been perfectly in compliance in every other way. I would hope that that would count towards something. Having gone through 10.5 months of in-house rehab and now being willing to do the outpatient for this THC addiction, Your Honor, we would ask for that opportunity. He has not had any other revocations on these hearings, on these cases. Again, this was all pled at one time. Yes, there was a big issue at a time in the past, but that was before his 10.5 months of in-house rehab. And he stands before you today acknowledging that he's got a problem, but not acknowledging that he's done anything wrong as far as what he was instructed to do by probation.
Okay, thank you for that. All right, you may call our first witness.
We'll call Marty Matthews.
And I've already sworn her in.
Okay. You answered my first question. All right, can you state your name, please?
Marty Matthews.
Ms. Matthews, how are you employed?
I'm the director of Spalding County Sentence Enforcement.
All right, and is Jeremy Kaler a probationer with Spalding County?
Yes, sir.
Is that Mr. Kaler seated next to Mr. Dutton over here?
Yes, sir.
And when was Mr. Kaler placed on probation?
For the first consecutive cases, September 19th of 2022.
Okay. And how many cases total were there?
3.
All right, and what were the case numbers?
21 SR 1618, 21 SR 1619, 21 SR 1620.
Okay, and those were to run consecutively?
Correct.
All right, and so 21 SR 1618, that case is completed.
Correct.
Was there a revocation filed on that?
But due to the transfer from JAG probation to Spalding County Sentence Enforcement, I don't have access to those notes through the data system we currently use. I would have to check Odyssey.
21 SR 1619, that case is run. The case is completed.
That's correct.
I can actually tell you what's in the clerk's file. I'm looking at it here. There
Yeah, I
was,
didn't realize Ms. Matthews didn't have it in front of her.
that's okay. It looks like there was an order filed on 3/20/23,
23.
and it was a revocation order where the defendant came to court, stipulated, and I added specific responsibilities to it. So I'll print copies for everybody.
Your Honor, it was based on a no insurance ticket and a registration ticket, Your Honor, and he came in and admitted, and it was.
Yeah, it's not, it wasn't a harsh response. So again, I'll print copies and give it to y'all in just a second.
All right, so Ms. Matthews, on the current case, 21 SR 1620, when did that case begin?
It began on September 18th of 2024.
And what charges?
Obstruction and battery, family violence, victim over 65 years old is what we have documented.
What's the length of that sentence?
24 months.
And was that a first offender plea?
That's correct.
All right, and Ms. Matthews, your office has filed a petition for revocation.
That's correct.
And the first ground of the petition for revocation is that Mr. Kaler failed to appear at a revocation hearing on May 1st of 2025. Is that correct?
That's correct.
All right, was Mr. Kaler noticed of that hearing?
Yes, sir. We're required to mail notice for anyone sentenced to come into court. We mailed that by regular UPS mail on April 16th, 2025. As of today, that mail has not been returned to my office as undeliverable. It was also mailed to the most recent address that he noted in his last online report.
And is Mr. Kaler's responsibility as a probationer to keep your office informed of his most current address?
That's correct.
And that mail has not been returned?
Correct.
And it was mailed out, you said, what date?
April 16th of 2025 to appear in court on May 1st.
So 2 weeks prior to the hearing. Now, is a condition of Mr. Kaler's probation that he submit to random drug screens?
Yes.
Has Mr. Kaler failed to submit to those random drug screens?
Yes.
All right, what dates did he fail to submit to drug screens?
The dates that he failed to submit would, when we contact them, we give them 48 hours to submit whether they go to an independent lab or choose to come to our office. So we contacted him on October 14th to submit by October 16th. We contacted him via email. On November 19th, we called him, left a voicemail, and sent an email for him to submit by November 21st. On March 25th, we called, his voicemail was full, so we could not leave a message. We also sent him an email to submit within 48 hours.
And is Mr. Kaler's responsibility as a probationer to keep your office informed of his best email address?
That's correct.
Is it his responsibility as a probationer to keep your office informed of his most current and best telephone number?
That's correct. I did check his most recent online report for that information, and the email address and the phone number that we were using for all of these contacts were the information that he provided on the most recent online report.
Did he respond to any of those phone calls?
No.
Did he respond to any of those emails?
No.
So when was the last time he actually provided a sample for a drug screen?
Was in 2023 on the previous case, December 8th of 2023. We got the results on the 8th, I'm sorry, he took the screen on December 1st.
So roughly 18 months since he's provided a drug screen.
Correct.
And Mr. Kaler's also received new charges.
Correct.
And what were those new charges?
Possession, use of drug-related objects, possession of less than 1 ounce, and possession of a Schedule I controlled substance.
And what's the date of arrest on that?
May 17th, 2025 was the date he, on or about he received the charges.
All right, was Mr. Kaler on probation with Spalding County Sentence Enforcement when he received those new charges?
Yes.
How long does Mr. Kaler have left on probation on this case?
He has 485 days.
In this case, it does indicate that he could go to non-reporting on this case.
Correct. Once all of his conditions were completed, he would be eligible to go into non-reporting.
Objection, Your Honor. They need to lay a foundation for that.
For the conditions of his probation? I'll ask the
That's
court
correct.
take judicial notice of the conditions of his probation.
All right.
Your Honor, I would love to submit this that actually has the actual box checked, but it doesn't say that it can go to non-reporting. It says that it is non-reporting.
Okay. Well, I will take judicial notice that the final disposition was filed with the clerk of court on September 19th of 2022, and that will be the document I will be using to make my decision.
All right, since we're using that, Ms. Matthews, do you have a copy? Of
I do not.
Disposition, all right, I'm gonna hand you. All right, Ms. Matthews, do you recognize that document?
Yes.
What is that?
That would be the final disposition for case 3.
Okay, and is that case 3, is that the case that we're discussing currently?
Correct.
All right, does that appear to be a true and accurate copy of the final disposition for 21 SR 1620?
That's correct.
All right, I'll tender that as states one.
All right. Any objection?
No objection, Your Honor.
All right. And Do you have an extra copy, Mr. Shepherd?
I can just go off.
Because I just printed an extra by mistake.
Okay, that'll work.
So my mistake is your copy.
Thanks, sir. All right, so Ms. Matthews.
You have a copy, right, Mr. Dutton?
Yes, sir. Yeah, I gave him one before there.
Just putting that on the record that Mr. Dutton has a copy already, Ms. Shepherd has one, Director Matthews has one, and now I have one. All right.
All right, Ms. Matthews, so on line 15, this is under the old form, so on line 15, it does have non-reporting underlined, correct?
That's correct. The options there would be either non-reporting or terminated. So it reads, probation shall be, and the court chose non-reporting upon completion of all special conditions, no violation in 0 months, is how that line reads.
Okay. So does that mean that it immediately goes to non-reporting?
No.
Okay, what does that actually mean?
Once his court fines were paid in full, he had a clean drug screen, then this case would be eligible to go into non-report because there's no other conditions on this case.
Okay. Has this case actually made it into non-reporting status?
No, there's a remaining court fine balance of $808.
Okay. So he was on reporting probation.
Correct.
All right. Was he allowed to e-report or was he reporting in person?
He was allowed to e-report.
Okay. And e-reporting involves reporting with an email, correct?
That's correct.
All right. And has he been communicating with y'all by email?
He's reported online and used that email that we contacted him through, but he has not responded to us from that email. On this case, there are responses on the previous case from that email.
Okay. And this is the same email address that y'all notified him of his responsibility to take drug screens on 3 different occasions?
Correct.
Okay. Now, he was also pled as first offender, correct?
Correct.
What's the balance left on this?
Days or money?
How many days are left?
485.
Do you believe he's a good candidate for continuing on probation?
No, sir. The court's instruction to my office is if you don't show up for 1 drug screen, that's an automatic warrant and termination of your case. Mr. Kaler got special treatment to some extent because the first request, they didn't phone call him. So I denied a warrant because I didn't think that was fair to Mr. Kaler. I instructed my staff to make sure they always call and email and use every available information they have to try to reach someone so we're not taking someone's freedom. And then I had a change of PO during this time, so then it went to another PO. And then just for additional information, just to be secure in my office, because we always try to make sure we cover all bases, we also reached out and emailed him on April 4th trying to follow up on a drug screen. We offered him the option to go get a hair and nail follicle and submit that by April 11th before this revocation was set.
And that was the revocation that was set on May 1st?
That's correct.
All right, and those efforts to get him to go get a hair follicle done, was there any response to that?
No response.
That's all the questions I have for Ms. Matthews.
All right, Mr. Dutton.
Morning, Greg. You said the mail that you sent to him was returned non-deliverable.
It was not returned.
Sorry, I'm sorry, so the mail that you sent him was not returned, or you said it was returned undeliverable?
It was not returned.
So, for your knowledge, it made it to the house?
Correct. I'm just stating that a lot of times when we have the wrong address, it will return to us. We'll document that. And I'm just saying, as of to date, we have not received that mail back as being undeliverable.
And your system where he checks in online has the ability to put notes in there, right?
He answers a bunch of questions, and those responses come over to us via email.
And that system you can edit at any time?
The defendant?
You can edit at any time?
No.
So there's no way through him checking in online that you guys can actually contact him through that? That doesn't count as contact?
We can't respond back to that. It comes through as just an email to us that we can only copy and paste into the report notes.
Okay. So when he checks in with the system that you control, you have no control over that system?
It's just a web address that he goes to. He puts his ID in, and he puts in the online password, and then it brings up questions. He submits those, and then it goes to whatever PO he chooses.
And what's that web address?
It's located on our website.
The Spalding County website?
Yes, sir.
But it's your website,
It's off our website, yes, sir.
okay? And you guys control that website?
I don't personally, if I want any changes or anything done to it, I have to get in touch with the county to
Okay.
make adjustments, and then I have to get in touch with my software provider.
Sure. So you have the ability to change what that website looks like and the questions that is asked?
Yes, if I get in touch with the county, yeah.
Okay. And that would include notices to probationers that they need to do something additional.
No,
Like-
that's not the way it's set up. It's just simply set up with questions. There's no way for us to submit anything through the online site of where they check in.
I understand that right now, it's set up so that there's no way for it to provide notice to him.
Mhm.
But it could be because you control it, right?
I would have to get in touch with the programmers
Right.
of Pronto to see if they have the ability. I'm not a software programmer, so I don't have the ability to do that, to
So-
change software programming.
So there's questions on there.
Mhm.
Who wrote those questions?
The software programmers for Pronto.
Who gave them what words should be there?
They utilized a different report from, I believe it was Cobb County.
Okay.
Is when we set that up.
And who gave them the report from Cobb County to use?
That I'd have to inquire with them. I
So
didn't ask
on,
that question.
so on their own, without any input from your office or county staff, they went to Cobb County, grabbed a Cobb County form and put it on your website so that they answered Cobb County's questions and not our questions, not the county's questions.
Well, we discussed them, but that's where the basis of the structure for the questions came from.
Okay.
They're
So-
all relevant to probation.
Sure. So what I'm trying to get at is you discussed it with them. And so in effect, while you guys were copying the Cobb County questions, which I'm sure are fine questions, it was really your call what went on that website.
For the questions, I approved the questions that are listed.
So through that same system, you could change those questions.
I could,
Okay. And through that same system, you could provide different notices and different questions, correct?
I could provide different questions. I don't have a form, it's not formatted to provide notices.
Okay, it's not currently formatted to provide notices, but it could be.
I'm not aware. I don't know if the programmers have the ability to do that. They would have to program the system to do that. As far as I'm aware, that no one who uses the Pronto software currently has that ability.
That ability being the notice question.
Correct.
Okay, good.
So we have a system of electronic reporting that doesn't provide us actual feedback for electronic reporting.
When they submit it, it comes to the PO as an email with just how they respond. So it comes from a non-reply email. So it's not even something we can reply back to.
So I'm just trying to understand the system. The system currently is set up that y'all have contact with a probationer every month through a system you have nominal control over, but no real actual control, right?
I would agree.
And that it's not set up to give any actual feedback to the probationer, correct?
Correct, yeah, it's just a way for them to report to us. That's not, there are requirements for us providing notices. So like say I noticed someone through a system like that, or say I sent someone an email and said, hey, you need to report to court on this date. By law, that's not gonna, that won't meet the tolling because it says in the tolling statute that I must notice them by USPS mail.
Okay, so again, we're currently using a system where the probationer believes they have checked in a two-way conversation monthly with probation. But we're finding out here in this hearing, even I'm finding this out here in the hearing. So I know I'm cross-examining you, but
I understand.
I'm exploring the system as
I
well.
understand.
That it's really a one-way communication, not a two-way communication. It's one-way from the probationer to probation office.
I would still consider it two-way because once they submit, then I require my staff to send them an email back to the email address that's provided in that online report, confirming that their online report was received, to provide them information that's relevant to their payment, when their next report date is, or anything like that. But in addition to that, I also require my staff, if they want a drug screen, they cannot include that drug screen information within that report. They
It
have
has
to
to be a
send it
separate-
completely separate, because I don't want people missing that.
So every month, your office receives these online reports through what is effectively a one-way portal, and then the response comes via email.
That's correct.
That email just clarifies what was in that one-way response. You have answered all the questions. We have received contact from you. Here's your balance.
Yeah, balance next report date,
Balance next report. And that's all that email contains.
correct.
And then if any other emails are sent, those are sent separately. Okay. And when you call, now you require them to call. I think that's very fair. Do you require them to leave voicemails?
Yes, absolutely.
Okay. But in this case, there weren't any voicemails left.
That's incorrect.
Okay, you testified earlier that the voicemail box was full, and so they never left a voicemail.
That was just on the call on 325. 11:19, we left a voicemail. 325, the voicemail was full, so we weren't able to. But that was outside of our control.
Sure.
And then when we called him on April 4th, we also left him a voicemail when we were attempting to offer him the hair and nail follicle option.
Okay. And you received no confirmation that he received those voicemails or anything? Or,
No, sir.
other than calling and leaving voicemails, have you ever had contact with him through the phone? Or has your office, I should say?
I briefly scanned the notes. If you'll give me one moment, I don't want to tell you incorrectly. That'll take me just a moment,
No problem.
All right, let's go off record and we'll just let it read quietly. Just let us know when you're ready to go back on record. Not on record. Mr. Dutton, not on record. But whenever we get finished with this, since you've represented both Mr. Kaler Senior and Mr. Kaler Junior, would your office be willing to provide us with like their personal information so that we can go through it on our end and make certain that we have the two of them sorted out correctly? Because I am looking through it and I do have some question marks next to a few things. I'll just get Bruce or Ashley to send that straight to you. Okay, ready, Kathy?
Yes.
All right. Mr. Dutton, you ready?
Yes, sir.
All right.
There's been no phone calls, no emails back on this case.
Okay. Let's go back to the e-reporting system. They sign in and they answer questions and they push submit. That sends an email summary of their answers to their probation officer, not to you, to the probation officer.
To the officer they chose, yes. Sometimes they don't choose the correct one, but yes.
Is that like a drop-down menu?
That's correct.
Okay. If it goes to the wrong officer, is there a protocol for them to just forward it to the right one, or do they just handle it?
What we do is we use the Teams chat option in the
Sure.
office, and so if
Yeah.
we're missing one, we have a group chat for all the POs, and we simply ask, does anyone have
Hey, did
this
you grab
report?
this one? After that is, when they push submit, what is the next screen that they see? What does it tell them?
It's a green box. I don't know the exact verbiage in it, but some kind of clarifying information that your online report has been submitted.
Does it tell them their next reporting date? Does it tell them if they need
No.
to do anything?
No, because that's generated based off the POs, what their availability is when they have to be in court, things like that. So those dates can sometimes change.
And in this case, we've got A and B. He failed to appear at the revocation hearing, and he failed to test on the 3 times that you guys sent him a separate email to test. But we don't have any kind of failed report. He's reported every time through that online portal.
That's correct, yes, sir.
Do you know what his monthly payment is?
It's probably.
Because I know it's y'all's fee plus like a breakdown of what his fine is.
His monthly payment is $117.
117?
117.
That's correct.
Has he ever been given the option of paying his fine up front and just having the monthly probation fee left? Has that ever been contacted? Have you ever been given a?
Since the beginning of this case, I did not see any documentation of that.
Okay.
I didn't check the notes prior.
Is there any, do you guys have any documentation that he's successfully completed a residential in-house treatment?
Because that first case would have been back at JAG, I don't have the notes for that case, so I can't speak to that.
Do you have any evidence or allegations that he has contacted or had any contact at all with Destiny Ritchie?
No, sir.
So we have here that it says probation shall be non-reporting upon completion of special conditions, no violations in 0 months. What are the special conditions in this case?
In this case, it would have been the no contact with Miss Destiny Ritchie. He would have had to obtain a valid driver's license, and then the drug screens, which are listed under the mandatory conditions, waived only by initial by 4, towards the top.
Okay. And when did this one start?
It started on September 18th, 2024.
Okay. And the first time he failed to drug screen was October 2024?
That's correct, yes, sir.
So even though this says probation shall be non-reporting upon completion of all special conditions and no violations after 0 months and 0 days, he was never actually asked until months later to actually do a drug screen.
Well, typically, I mean, it began on September 18th. The first one was on October 14th. So that's less than 30
So a
days
month.
from the case
A month
beginning.
later.
And so we typically, that would have been the first month, the first request.
Was there any drug screens in the previous that this is consecutive to?
Yes,
So he has screened on probations that this is consecutive to.
correct.
And this says that he has to, it'll go to non-reporting immediately upon meeting all those special conditions. He hasn't violated any of those special conditions other than not screened for this particular one. But again, the special conditions don't include the fines and fees.
It does.
Okay, sorry. You just read out all the special conditions and the fines and fees weren't part of it. So can we go back to what the special conditions are?
Well, the special condition, the fines and fees are on most cases. And then this particular case, I was mentioning what his special conditions were on this case.
Yes.
They differ.
That's right. And you read out a full list of all the special conditions, and the fines and fees were not on that list that you just read out for the special conditions in this case.
Correct.
Okay, so the fines and fees are not special conditions in this case. So him having not paid, still making payments towards that fine, is not a violation or isn't a non-completion of the special conditions.
I guess you could have seen it that way.
Okay, so he's on contiguous probation. He does have successful screens during that time. The paperwork rolls over into the next one, and it says at 0 days he will go on non-reporting, and yet he's still reporting online with you guys every month. Okay. And he's paying his fines and fees online every month as directed. So then, when he tested for these other 2 cases that have already terminated, did he ever fail any of those tests?
I don't
There's a
have the.
there's a jag lag, but
Yeah, I
we can
don't
assume not, or they would have violated them. Yes.
I would assume, but again, I don't have those records to.
But there's not a violation, so we can all kind of assume that he didn't, or they would have
Well,
violated.
they would have already been addressed.
Right, but it would have been addressed via a violation.
Correct, yes, sir.
And there's not a violation other than the 2 tickets he got, which came through.
Right.
But we do have these 2 here with 2 years of probation where he did screen, and they contacted him for those screenings, and he screened. Again, some of the time we're assuming because that was JAG probation, but even during your office's time, he successfully completed for these probations all the screenings that you guys require.
I believe he was in person for the previous cases, and that definitely makes it easier
Sure.
to screen in person. And so when people go online, that's definitely a risk that can happen with the communication. So I think that's how we got those previous screens. He was actually there in person.
So there was actual communication.
Yeah, in person.
Okay. Do you have any records of emailing him and getting responses to those emails in these?
Yes, I do. I believe I saw some in the 21 SR 1619 case. I believe he had communication. He was going back and forth with Ms. Rich.
Via email.
Yes, sir.
What about telephone?
If you'll give me a moment, I'll review those.
Sure.
Don't see any communication back to September 20th of 2022 via phone from Mr. Kaler to my office. There are email communications.
And we don't know before that because that's when Spalding County took on citizen enforcement.
The notes I have all the way back to September 20th of 2022.
So we have a history, a 2-year history of him reporting, testing, doing everything he was supposed to do, both via email and even though and no missed phone calls or anything like that. And he's paid all his fines and fees. He's even gone to the in-house residential treatment. And then this case starts. And he's already tested, and there's no other special conditions he hasn't completed. And from his point of view, he has contact every month coming to your office via going in and checking on the website, answering your questions. Have you gone in and looked for yourself sort of a test case, what it looks like when they go in and answer those questions and what they see?
Yes.
And but it doesn't give them any other feedback. It's your testimony that doesn't give them any other feedback other than this, you have successfully entered, like you've successfully sent it done.
Once I hit submit, yes, sir.
How do they know when they're supposed to check back in the next month?
The PO will send them an email.
And it's your testimony today that procedure has never changed. That's always the way that they receive the date for their next check-in.
I mean, that's our normal procedure. I mean, I guess if the PO chose to call, they could, but that's not typical procedure.
But in that email, they don't tell them about any extra required drug screens or anything extra, just their next reporting date.
If they had other conditions, they would address, like, you know, say had the community service,
Okay.
family violence, they would address the conditions on the case in the one referencing their next report date, or if they hadn't made their payment for that month, they would let them know, hey, you need to get this payment in for this month, next month you need blah, blah, blah.
Is there any record of him being late on a payment or needing that prompter as opposed to having paid like he was supposed to exactly on time?
I'd have to review all of the different emails to him, and I could do that if the court would like.
But if there was a late payment, that wouldn't necessarily trigger a hearing though, right?
No, absolutely not.
He would have to not pay for the month and have the month roll over, and then that could trigger a hearing.
It could, but typically does not. We're not gonna be that harsh on
Okay.
just payments alone.
But
It'd have to be kind of rather significant.
sure, but he's also not behind at all, according to your.
That's correct, yes, sir.
Okay. In all of the years of this, the probation he's been on, has he ever informed you that he's moved or changed his address or changed his phone number or anything like that?
I know I did see communication back at JAG that his phone number changed that quickly. The way they documented it, it jumped out to me today when I was scanning through the notes. So I do know that that has happened. I'd have to go through a little bit more. Well, no, that's gonna be a family violence. I'd have to go through a little bit more to see. I know there was a different email address at one point. Not the most recent one that we're using. I believe that was on a previous case.
And we're sure that we're using the right one now.
We're using the one that Mr. Kaler has put in his most recent online report that he submitted.
Because one of those questions is, what's your current phone number? So he has to re-up and
That's correct. He has to put that in every single time. Yes, sir.
Okay, and that's the one we're using.
Yes, sir. Yes, sir.
In the revocation, you have in part one here, above defendant appeared in Spalding County Court and under the provisions, first offender without adjudicating guilt, a period of 24 months for the offenses of obstruction and battery, family violence, victim over 65 years old. Where did you get that information? Family violence over 65 years old?
This is an older case, and we had significant data errors between the transfer of information from JAG to the new software, where the charges weren't the same, and when they merged it, there was errors, and my assumption is gonna be this is an error in the charges, that there wasn't a relative one in the system, and no, we just have not caught that error.
And I'm not blaming you. You guys do fantastic work, but we do have the charging document here
That's correct, yes, sir.
for 1620, and it does not have victim over 65.
That's correct, yes, sir.
Okay, so we know that there's an error
That's correct.
in specifically the probation system. It's not the court. The court has this all correct. But somewhere in your system, there is an error of what he's even pled guilty to and what he's charged with.
Yes, sir.
Correct. Okay. So now we're all jumping on the bandwagon of attributing this to JAG and the changeover. And we agree that that's probably what it was. But could it have been anything else?
No, sir.
Could there be any other errors or omissions? Could there be any other errors or omissions in that changeover paperwork? Is it possible?
Well, there was another error. The money
Okay.
was allocated to the wrong cases, so I had to do separate modification orders. I'd have to look at his case specifically, but having three
Sure.
cases, most cases, I had
Sure.
to do multiple orders for each case. So the money, I know I saw documentation that it was allocated incorrectly to one of his cases, so that was another error.
Why Matty T did it like this, I do not know, but here we are. So we know of 2 errors based on that transition.
Mhm.
Is it possible, could it have happened that there are any additional errors than that? Is it possible that there are more errors than the 2 that we already know about?
I mean, I think that's speculation,
Yes,
but I mean,
absolutely. Is it possible?
I'd say it's definitely possible.
Okay. So other than the communication on this one, on the 1620, this last case, the communication breakdown about coming to the revocation hearing and these 3 tests, there are no, and of course, being picked up with the stuff, which is again based on this revocation. Had A and B not happened, he would have never been charged with C because he never been picked up. In theory, I mean, he could have run a stop sign and get picked up, but there's no other history at all except for the registration and insurance ticket, which we came in, immediately answered to. He was given a phone call in that one, or an email. How was he notified? Was that JAG or was that y'all?
I believe that's gonna be JAG. I feel like I saw it in their notes. That would have been JAG, and he was mailed a petition for that hearing on March 16th of 2023.
So it was via mail, like U.S. mail.
Correct,
Okay, and he did show up for that hearing.
correct.
So, and what was the result of it? He was put on strict compliance or something, like it was, like he didn't have to do jail or anything like that.
Payments of 118 monthly, 0 tolerance for 120
You can keep
days.
it 120 days. Now that 120 days is long run.
Of course.
So JAG probation was able to get in touch with him and get him here for a revocation hearing. Get into all his drug screens. Enforce the residential treatment. But, oh, that's right, you guys don't have a record of his residential treatment.
It may be on the previous case. I don't have, was that a probation case or was it?
It's one of these 3. That was 1618.
And for record purposes, I'm handing out the documents as we're discussing them to whoever needs to hold them. I've printed copies, so I've handed Mr. Dutton a couple things, and I just handed a copy of that final disposition to.
I'm fine.
Okay. Just if somebody needs something, they'll just let us know.
We have that he was reporting in person as of October the 5th, would have been shortly after he was sentenced on October 21st of 2022. He advised us that he had already completed, and he forwarded an email with the completion letter on October 21st. And so we did require him to do the 30 days that was on this disposition.
Okay. Was that Spalding County Sentence Enforcement or was that JAG?
That was Jack.
Okay.
When did y'all open again? July 1 of 23?
That's correct.
Okay.
23.
I know I was part of that. I just, my years are, I'm getting older.
It's been 2 years.
My years are 2 years? Look at that. We're all still here.
But that wasn't attached to the 1620 at all.
No, sir.
So we have a history of JAG getting him to report, right? Getting him to test, yes? And then getting him even to a revocation hearing.
That's correct.
Yes. But when he started with Spalding County Sentence Enforcement on a case marked non-reporting after 0 days, Spalding County was unable to get him to test on three different occasions That's what B alleges. And failed to get him to a revocation hearing on May 1st, right?
Well, on the second case, he was with Spalding County Sentence Enforcement, that would be 21 SR 19.
Okay.
So he did report in person on that case in the office. And we did get a drug screen on that case as well. He didn't violate it, so we didn't have to try to get him to a revocation.
Okay. So, and he moved on this case when it was completed. Number 15 is not checked, so this is in-person reporting and in-person drug screens, right?
No, he was on online reporting. His PO allowed him to go to online reporting on that case as well. He began in person. It looks like he was moved to online reporting.
Early.
Well, it appears like in October of 2023. Quickly going through there.
So essentially all of the 16-19 case, he was online reporting.
I'd have to double check the start date of it.
Because September 22, he had started 16-18. So September 23, he would have started 16-19, right? It's a year later. So in October, he's allowed to go electronic reporting.
Correct.
And there's no issues through all of that year with 16-19.
Correct.
Okay. And then he gets into the 16-20 case that says no reporting, but he continues to report electronically. And then there's this breakdown in communication that has from A and that created A and B on the revocation.
Correct.
Are you aware of any health conditions Mr. Kaler has?
I'm not personally aware, no, sir, and I'd have to go through the online reports to see if he mentions that.
No problem.
His PO did not prompt me with any information on that.
Okay. Are you aware of any health conditions he's experienced, health issues he's experienced while in custody awaiting this revocation hearing?
No, sir.
Okay. No further question.
All right, redirect.
Pretty well beat this horse, but I got a couple real quick. So, Ms. Matthews, you said that the probation officer will send a probationer an email notifying them when to report online?
Correct.
Okay. And that was done with Mr. Kaler. He was sent an email to when to report online.
Correct.
And Mr. Kaler reported online.
Correct.
So we could assume that he received that email.
We can assume, yes, sir.
Okay. Is that the same email address we sent him notifying him to take a drug test?
Yes, sir.
Okay.
And if those emails would have been back to back.
Okay, so that email, he was responding to that email by reporting online, just not responding by taking the drug test?
Correct.
All right, that's all I have.
All right, any additional cross?
Yes, Director Matthews, that system was working fine for all of 16-18 and 16-19, correct?
What system?
That Mr. Shepherd just described, reporting online, emailing,
Well,
it was working as designed.
16-18 appears to
Was
be
Jack.
mostly in person.
Okay,
16-19 began in person and then went to online. And he often communicated back and forth with Miss Rich on 16-19. It's just, it looks like the last email where he responded back is around May 8th of 2024. And that would have been on 16-19. All the further communications, she still sends him emails, but I don't see where he responded back to those. But he was responding back and forth. And he, I can check real quick to see if he's ever missed an appointment. No.
so you never missed an appointment? Okay, no further question.
Okay. You may just stay in your seat.
Yes, sir.
All right, Mr. Shepherd, you may call your next witness.
Judge, that's all the witnesses say will have in this case.
All right.
We'll rest.
All right, Mr. Dutton, state's rested. Do you have any witnesses or evidence to present?
Yes, Your Honor, would you like to call Mr. Kaler?
Okay, we're gonna leave him in his seat. Mr. Kaler, grab that microphone, pull it up close. And as Mr. Dutton has already explained to you, when you're finished with your testimony with Mr. Dutton, Mr. Shepherd will be asking you questions and you will be required to answer those as long as they're approved by the rules of evidence.
Yes,
Okay?
sir. Yes,
All
sir.
right, Mr. Dutton, you may swear in your client and begin.
You swore him in previously.
That's right, I did.
Mr. Kaler, state your full name for the record.
Jeremy Dean Kaler Sr.
Right. And there is a Jeremy Dean Kaler Jr., correct?
That's correct.
And he's also a former probationer, correct?
Yes.
And previously, when you pled guilty to 1618, 1619, and 1620, these three cases, correct?
Yes.
A little, I can't hear you. Even
Yeah.
with the mic, I can't hear you.
Yes.
And your attorney at that time was Matthew Taylor, right?
Yes, sir.
Now you were at Matthew Tucker, keep going. Tucker. You were asked during the guilty pleas for these if you were satisfied with the work Mr. Tucker did for you, and you answered yes to those. Otherwise, the court wouldn't have taken your plea, correct?
I do not recall. I'm pretty.
It's a long time ago. But we'd like the judge to take judicial notice that is so, that's part of the boyfriend.
I'm comfortable taking judicial notice that had anything happened during the plea, I would have stopped it immediately, or even if I'd even sensed something was off, I would have stopped the plea.
But now that we're this far into the case, has your opinion of Mr. Tucker's representation of you changed?
Absolutely.
All right. Can you give me, tell me how that's changed?
Well, for one, I didn't. To me, he was being disrespectful. He was on the phone the whole time he was in court on his phone. He didn't really explain everything to me as good as he should have. I don't believe. But
Now, he did explain the details of 1620, this last case that we're on now today, right?
I really don't recall. It's been a long time.
But you went over this
Yes.
and saw number 15 here, probation shall be non-reporting upon completion of special conditions, no violation.
That is correct. Yes.
So is it your impression that 1620 was non-reporting probation?
Yes, sir. Because I was on non-reporting for the whole second one, and every month they said I need a report from the 1st to the 15th, and that's what me and Miss Rich communicated. So that was my time period the whole time, 1st to the 15th. So that's what.
How did you communicate with Miss Rich? That's your probation officer?
Yes, sir. Yes,
How
sir.
did you communicate with her?
She called me sometimes, and I think I had a couple emails from her. But after so long, it started saying after you check in, it says your check in successful, and I knew my check-in date was from the 1st to the 15th. So that's how I checked in.
So when did you stop receiving those communications from her? Do you know exactly?
No,
Can you give me a ballpark?
I really.
Like which month? Was it around May? Was it was it the summer? Was it the spring?
I don't really recall.
Okay. But at some point you stopped receiving information from the probation office,
Yes.
but you continued to check in on your assigned date
Yes, and pay my fine.
and pay your fine.
Yes,
And those dates were effectively the same every month.
Yes, that's what she had told me. It would be the 1st to the 15th every month.
Okay. So sometime between the 1st and the 15th, you were to check in, not a specific day?
Not a specific day, just in between the 1st and the 15th.
But you always checked in on the right date specifically.
Yes, I never missed a date, never missed a payment.
How did you know each month which day that would be?
Anywhere between the 1st and the 15th.
Okay, so it was just check in online sometime, one of those
In
days.
between the 1st and the 15th.
Now, you did have a revocation in this, not on 1620, but on 1619, right? Last year sometime?
Were the 2 tickets?
Yeah.
Yes, sir.
What were those 2 tickets for?
I didn't know my insurance had got canceled, so it caused my my registration gets suspended also. So as soon as I got the tickets, I came to Miss Rich and told her, I got these 2 tickets, you know.
And they told you after that you had a revocation hearing that you had to come to.
Yes, for them 2 tickets
How did they tell you? That
in
you had
person.
In person.
I'm so sorry,
Sorry.
and I need you to, I'm so sorry, if you can speak up.
Oh, yes, ma'am.
Not overspeak.
Oh, yes, ma'am. Sorry.
So she told you in person about your revocation hearing.
Yes, when I reported and told her about the tickets, she said that we'd have to go in front of the judge, and then she told me when the court date would be. So we went in front of the judge, and they did 120 days of zero tolerance.
Do you remember when that was?
I do not recall.
You've got a lot of fines on these 3 cases, 685, 685, 735, 735. That's a few $1,000s. And you've got approximately $800 and some change left, right?
Yes, sir.
And in addition to that, you've been paying a $65 a month probation fee?
I just paid 118.
118? Okay.
Yes, sir.
Have you received, on this 1620 case, anything in the mail from probation?
I have not received anything in the mail.
Have you ever received a phone call in this case or a voicemail just about taking a test, a revocation hearing, anything like that?
No, sir.
Have you received any phone calls or mails from probation at all regarding 1620?
No, sir.
Mr. Kaler, had you received any communication about taking a test, would you have been capable of taking that test?
Yes, sir.
How many tests have you done total? Do you remember?
I do not recall.
More than one?
I'm sure.
Less than 10?
Yeah, yeah, less than 10.
Less than 10?
Yeah.
But every time that you were called, you immediately went within the 48 hours and tested.
Yes.
Now, one of these, 1618, required you to go to 30 days in jail unless you completed a successful residential in-house treatment.
That's correct.
Did you complete that treatment?
Yes, sir.
Where did you go for that treatment?
I went to Wilmington, North Carolina at a facility called Hope Life. It's a 10 to 12 month program, and I completed it successfully.
How long were you in that program?
Roughly 10 and a half months.
Okay. Was there aftercare with that program?
No, sir.
Have you done anything towards your addiction issues since leaving this residential treatment?
No, sir.
You haven't attended any AA meetings or NA meetings?
I have not.
Now, but this treatment was really based on a methamphetamine addiction that you
Yes, sir.
When is the last time that you indulged in that addiction?
In methamphetamines?
In methamphetamine.
2018 or before I went to that program.
So 2018, so 7 years.
Yes, sir.
But you do admit that you have used THC oil.
Yes.
Why are you, what for?
I've got a lot going on. My mom just passed. My grandmother passed 2 weeks later. My dad's identical twin brother just passed. And 2 of my really good friends passed. I just had a baby. I mean, I had a lot on me, and I really ain't no excuse, but I was just overwhelmed, really.
So it was a coping mechanism.
Yes, sir. And my dad's actually at home. I'm his main caregiver. He can't eat or drink nothing. He has a feeding tube. He's 87 years old, and I'm his main caregiver, so I just had a lot on me.
When we first spoke, we spoke about some additional treatment options.
Yes, sir.
What would you like the court to do today if given those options? What would you choose?
Well, I'd like to get into that program we discussed.
The Veterans Mental Health Court?
Yes, sir.
If the judge sentenced you to go into that Veterans Mental Health Court, would you attend all the classes?
Yes, sir.
Would you report to court twice a month as ordered?
Yes, sir.
Would you be able to pass drug screens, or at least, we know because THC stays in your system a while, have descending amounts of THC oil showing no new usage?
Yes, sir.
And you can commit to that today.
Yes, sir.
And you're aware that if you commit to that and the judge, out of his benevolence, sentences you to that, if you fail, they will haul you back in here and they will revoke the balance and you will spend it in jail.
Yes, sir.
No further questions.
All right, Mr. Shepherd, Cross.
So, Mr. Kaler, you said just a minute ago that you got the emails from probation telling you to report online. Is that what you testified to?
Back on the 2000, or the first case.
You were online reporting
Yes, sir.
on 20 SR 2019 and then 20 SR, 21 SR 1619 and 21 SR 1620. You said you were on online reporting for those two cases, right?
Yes.
Okay. And you received emails from probation telling you when to report.
No, me and Miss Rich discussed it. She told me to report every month between the 1st and the 15th.
Okay, so you're saying you didn't get any emails from probation?
I did communicate at first to the email. Yes, sir.
So you have a working email?
Yeah.
All right. But you were getting emails telling you to report, but not the ones telling you to take a drug screen?
No.
Commissioner, he's asked and answered. He said specifically he was told via word of mouth, not via emails.
All right, overruled.
Okay. So it's your testimony you never got any emails telling you to take drug tests?
That's correct.
Okay. Now, that has nothing to do with the fact that you wouldn't have passed those drug screens?
Not at all.
Not at all, okay. Now, you were arrested for drug possession on May 17th of 2025, is that correct?
Yes, sir.
Okay. So prior to May 17th of 2025, were you using drugs?
Very shortly prior to that, yes.
Very shortly prior to that. Okay. So in October of 2024, your testimony is you would have passed a drug test?
Absolutely.
Okay. And then in November of 2024, you would have passed a drug test?
Yes.
Okay. In March of 2025, you would have passed a drug test?
Yes, I just started using marijuana again recently.
Just recently started using?
Yes,
drugs?
sir.
Okay. Now, you said a few minutes ago, the last time you used meth was in 2018.
Well, whatever, I don't recall the date, right before, when I had to go to that program.
You said 2018.
I don't recall the actual date. It's when I went to the year I went to the program.
All right, well, you said 2018, so but we'll give you a couple of years on that. We can go
what-
1 year or two the other way. All right, but you had a meth charge from September 15th of 2021, correct? You were arrested for methamphetamine possession?
I don't recall that, no,
You
sir.
don't remember that? Okay. What about this case, the one that we're talking about today? That was originally a meth charge also too, right?
No, it wasn't.
Okay, so how many times have you been arrested for meth possession?
Back then, I think twice.
Twice? Okay. And then you just wait between 2018 and 2025, you just didn't use any drugs at all? That's your testimony?
No, I went to that program and I got clean. Well, whenever I went to the program is when I got clean.
Okay, but clean would not be getting arrested for felony drug possession in May of this year, right?
That's correct.
Okay. And you didn't receive any mail from probation telling you you had a court date in May?
I have not received a mail, no.
So your failure to show up in court, that's probation's fault?
I'm not saying whose fault it is. They already had some errors in the paperwork. I don't know. I don't know whose fault it is. It's just, I see it as miscommunication.
All right. And your failure to show up for 3 separate drug screens, that's probation's fault because you didn't get the
Miscommunication is all I can say, sir.
All right. And you didn't get the phone calls from probation either?
I did not.
Have you changed your phone number in the last few years?
No, sir.
So you've had the same phone number?
Yes.
All right. Have you changed your email in the last few years?
I did have one email, and then I did change over to another email.
Okay, did you give them your email address?
Yes,
And that's the one they were using to communicate with you?
that's correct.
Okay, so you just didn't get the ones telling you to take a drug screen, but it had nothing to do with the fact you wouldn't pass that drug screen?
That's correct. I didn't have no reason to check my emails because it said every month that my check-in was successful, and I knew that I was supposed to report between the 1st and the 15th.
Okay, so you don't check your email at all?
Not just randomly, no.
You don't, so why do you have an email?
Everybody has one.
But you don't check yours?
I mean, I check it often, but I mean, not. I hadn't seen nothing on there.
You just don't check the ones telling you to take a drug test?
Objection, Your Honor.
Yeah,
That's all I have.
sustained. Okay. Any additional directive of your client?
Sorry, I was just prompted by Mr. Keller. Mr. Keller, while you were incarcerated waiting this revocation, have you had any health issues?
Yes, sir.
What happened while you were incarcerated?
I actually had a mini stroke. I just got back from the hospital yesterday, and they still have still failed to give me any blood pressure medicine at all. My blood pressure was 154 over 104 yesterday.
Did they put you in the medical ward for that?
I was in the hospital, Spalding County Hospital, for 2 days, and then when I came back, they did put me in the medical ward, in the medical side, but they still haven't given me any blood pressure medicine.
When they brought you to court today, they took you out of the medical ward to go to court?
Yes.
No additional question, Your
All right. You recross?
No, sir.
All right, then that evidence is closed. Any additional witnesses or testimony?
Honor. We would just ask the court to take judicial notice of what I'm sure the jail could provide for that he had a stroke. In fact, it was one of the guards that made me aware of that this morning.
That's fine. Yeah.
Okay, that's fine. I don't mind factoring that into the decision. All right, thank you. All right, anything else?
Just argument, Your Honor.
All right, then rest. Mr. Shepherd, any rebuttal?
No, sir, Judge.
All right, you can go first, last, both.
I'll close.
Okay, Mr. Dutton, the floor is yours.
Your Honor, we have 3 cases that I'm not sure why it was done via 3 cases, and there's a first offender on one of them. Why a first offender was used on a misdemeanor, it's overly complicated, but it is what it is, Your Honor. That said, we have a gentleman who has been on probation for 2 years, nearly 3 at this point. He, other than the times in question here, routinely has reported, had perfect attendance, has paid his fines and fees, has continued to report even after this. There were lots of opportunities for him to not report, lots of opportunities for him to fail, to abscond, to not pay. None of those he availed himself of. Every single time he's reported, every single time he's tested. Here we are. He begins what he believes is a non-reporting probation. It was explained to him as non-reporting probation. And so he's not on the lookout for any additional mailers, any additional phone calls, any additional voicemails, even though in the past, when he wasn't on non-reporting, he received plenty of those, responded to all of those, did everything he was supposed to do. He completed the in-house rehab, and yet has, albeit relatively lightly, now fallen off the wagon. He is requesting aid for that. Your Honor, did he violate his probation? He has. Is it because of his drug use? Is it because of his coping mechanism with his THC oil? I'm sure that's to blame here, certainly for C. At the end of the day, Your Honor, this is a man who has tried his best, has shown repeatedly that he has the ability to do exactly what is asked of him, and has committed here in open court under penalty of perjury that he will do so if given the opportunity. He was given no aftercare from this in-house treatment. Again, it's not necessarily the best policy there, but we're in a situation where he is an excellent candidate for our Veterans and Mental Health Court. He's an excellent candidate for being able to be given this chance. Your Honor, we would ask that you, I'm not sure if logistically you can do this. We would ask that you revoke the balance, but hold that and suspend it upon completion of the Veterans and Mental Health Court. He will be able to bond, or be able to get out of jail today, and will immediately contact Ms. Leslie and begin the process of starting in that program, and will continue to do so until accepted and stay with that program, and then successfully complete that program. This will allow him to continue to work to support his child, continue to be at home to support his 80-year-old father on a feeding tube, and most importantly, give him the ability to recover from the addiction issues that he's still left with. Your Honor, overcoming a methamphetamine addiction is a tremendous feat. A tremendous feat. Your Honor, he has overcome that addiction. He still has other issues left unresolved. He just needs our help with those addiction issues. Your Honor, that's what we would ask the court to do.
All right, thank you. All right, Mr. Shepherd.
This is everybody else's fault. It's the probation's fault. It's the treatment facility's fault, apparently. It's Matt Tucker's fault. But I mean, whose fault is it really? It's Mr. Kaler's fault. This is 3 different cases because it's 3 different incidents. 3 different incidents of family violence that he's on probation for. One of them, we've already had a revocation because he failed to abide by the law on the first case. He's had numerous prior meth charges. This case, 1620, had a meth charge attached to it that was dismissed by the DA. I don't know why, but it was dismissed and sent down to us, but that included a meth charge. Now we've got new drug charges. We've had 3 different screens that he missed. He ignored repeated calls and emails to come take the screens. He gets the emails to report, doesn't get the emails to take the screens. That's, I mean, why would that be? Sure, it had nothing to do with the fact he was doing drugs. He got arrested again for drugs. I think the clear answer is here. He ghosted this for 6 months because he had fallen off the wagon. Addiction is a beast. I mean, it is. It is. And we all have people that we know that are suffering from it, struggling with it. We deal with defendants all the time in this court that are dealing with it. It is a beast. But what happened here is Mr. Kaler fell off the wagon and he ghosted us for 6 months. He ignored repeated efforts to get him to take screens because he wasn't going to pass those screens. If he wanted help, that's the time to ask for help. We've already tried rehab. We already tried that with him in this first case, the first of these 3 family violence cases. It didn't work, unfortunately. But Mr. Kaler has showed a repeated pattern of family violence. He showed a repeated pattern of serious drug use. This news case is marijuana, which on the, and I think Mr. Dutton said this, on the grand scheme of things, drug-wise, that's on the way on the low end. But he showed a repeated pattern of methamphetamine use. We've tried rehab. We tried it. Again, very suspicious that he's just not getting emails telling him to take drug screens, and then he gets locked up for new drug charges. I think we all know why he was ghosting us on that. He's not a good candidate for probation. We tried the rehab on the first case. Obviously, it didn't work. I hope he can do it again later in life. But right now, he's not a candidate for probation. He's just not. We're asking you to revoke the balance of the 485 days and also revoke the first offender. He should not be entitled to get first offender out of this when he's utterly failed to do what he was supposed to do.
All right, thank you, Mr. Shepherd. Thank you, Mr. Dutton. All right, the evidence, as I've heard it today, is that we have 3 cases that ran back to back to back. 21 SR 1618. And that one, he went to treatment, got out, came back, participated with JAG. The very end of this case, by my math, would have transferred over to sentence enforcement right as they were opening up. So that one's closed. I'm good with that one. Moving on to 1619. Again, this is context only. That's our second case. This one was a battery family violence. It was a straight conviction. There was no first offender. So he is convicted of is he currently a convicted felon?
I don't believe so, Your Honor. However, again, that's the weirdness of this. He's pled guilty to 1 domestic violence charge and then pled first offender on a second domestic violence charge. The first offender doesn't do anything.
No.
Because he's
That's what I was trying to make certain of. So,
Which
okay.
again is a weird thing to have done. Why would you even have used it?
I don't remember, and Mr. Tucker's not here. So, all right. So on the second case, 21 SR 1619, that is a family violence case. There is a conviction. He has lost his firearm rights, as well as has to deal with the remainder of that for his days. Which brings me to the case at hand, which is 21 SR 1620. On that case, I will acknowledge that I did put sentence enforcement in an awkward spot for the specific line of 16, which said that upon completion of all special conditions, anyone who has seen a recent final disposition in this court knows that it now reads that they may go to non-report or be terminated upon completion of all conditions. So I've corrected that in the current version, and so that is nobody's fault but my own. So I will give Mr. Kaler some understanding at the beginning of his transition period that I do believe there was a legitimate point of confusion. I will say, however, though, that once we get into it, that the sentence enforcement team is very diligent about reaching out, communicating, phone calls, emails, trying to make certain that they give everybody they can as many opportunities to engage as they can. I do find it suspect, frankly, that an email address that worked perfectly in the previous two cases is not working in this one, or he didn't check it, or the combination of both, as well as, frankly, the phone calls that should have made it to him, that should have at least gotten his attention that he needed to communicate in some way. So I do find that it is more likely, because again, this is not a trial, this is by preponderance of the evidence. I do find by preponderance of the evidence that it is more likely that sentence enforcement reached out and that he did not appropriately engage, as was his responsibility. But I did want to acknowledge that the initial confusion over being non-report was reasonable and understandable, and it is not sentence enforcement's fault. They are only responsible for executing the sentence I gave them. I gave them a poorly worded sentence. I've corrected that on future ones. That's the best I can do. I've already said sorry to her because I've put her in this position with my language. Okay, so that with that said, we also have an admission that there are new felony charges. Those are upstairs. Oh, I'm like, what is that noise? For the record, it's a jackhammer outside. So I don't think that's part of the film crew.
They're thrilled by it too. They're kind of film.
Wow. All right. So so where that leaves us is I do find that there's proof by preponderance of the evidence that he did fail to appear after being properly noticed on May 1st, 2025 for hearing. I do find that he did fail to submit on that one. I am going to modify that one a little bit. I'm just going to leave the March 25th, 2025 miss. So I'm giving him his first two for confusion purposes because those are mine, but I'm leaving the last one on because I think by that point, a reasonable person would have known something was wrong and he needed to engage. Obviously with the felony, that one's obviously there. It's a big deal. It is, I get it. It is THC oil, but it is still a Schedule 1. And I haven't heard any evidence of a low THC card or anything to that effect. All right. So with that said, I'm going to do a little bit of a mixed bag here. I have a conviction that I'm happy with on 1619, where he is convicted of a family violence charge. Therefore, I'm mixing the bag. I'm revoking the balance and I'm leaving the first offender. He can keep it, but he's going to jail for the rest of the time. So that's what you get out of it. If he is truly, now I'm going to keep an eye on this one. I'll go ahead and tell you, if he is truly committed, then he can do the drug court upstairs. Like, I don't think us engaging in it at this point is the solution. I think his future is Superior Court, drug court, and they can handle it from there. So I also have not yet put someone in our accountability court without a recommendation from the solicitor. And I'm not interested, Mr. Kaler, in making this my first. He's not the candidate I'm looking for to put someone in there over Mr. Shepard's objection. So he would need to be some sort of crazy rock star for me to do that. So that's my opinion. That's my decision. So the balance is revoked. So what is it for? 45. So 45 is revoked. Credit for any time that he served, which I think he's been in about 19 days. terminate the balance if I've missed anything. He gets to keep his first offender. That closes out everything with us. And then again, I will be very curious to see if he engages, as he is saying that he will, with his felony charges and goes into drug court upstairs. And of course, I'll know that. So you have 30 days. Go ahead.
If, and I don't expect upstairs to move very fast, but if we can get him approved for drug court there before this runs, is there a chance that we could suspend whatever is still left so that he could go? I know that that's moving pieces outside of this room.
Sure.
But
How about this? If that happens, send an email to myself and Mr. Shepherd. We'll have an off-record conversation. But again, I don't think you're going to
I don't
get them.
expect him to move very fast.
They're not going to move in that time frame. But if somehow you make magic happen, just send an email to myself and Mr. Shepherd and Director Matthews. Sorry, I meant to say all four of us. And we'll go from there. If you'll come get this, you and your client sign it as to form only. You have 30 days from today if you wish to appeal this decision. You have 6 months from today if you wish to use your habeas rights. Anything else? This closes this out for you altogether, right? You have nothing else you have to do with him. Okay, Mr. Shepherd, there's no other cases or anything else?
No, sir, I don't believe so.
Okay,
Just
so
the felony.
he's superior courts from this moment forward.
I'm gonna take a minute to explain.
Yes, that's fine. Just feel free to put on there for, all right, then I'm going to say, issue the warrants, forfeit the cash bonds. Court is adjourned. We have accountability court this afternoon, no court tomorrow, and then arraignments on Monday.